Dr. Babatunde Irukera joins us next. He is the Executive Vice Chairman and the Chief Executive of the Federal Competition and Consumer Protection Commission, that's the FCCPC. Good morning. Thank you for coming on. Well, it's always, I mean, some of the cases you're handling right now, very worrisome cases, particularly the one that concerns these two ladies who had visited the hospital and going through the commentary. I don't know who will read through, and the person's heart will be broken about some of those cases. A case of a certain Nomolara and Peju Ugboma. So give us a background to what you're doing about this.
Well, so the role of the FCCPC pursuant to the Federal Competition and Consumer Protection Act is to ensure, with respect to services and goods that consumers use or purchase, that there's a measure of satisfaction. And that comes in two ways. First, complying with applicable standards, and then secondly, is level of responsiveness and sensitivity when there's dissatisfaction. In professional services, it's quite tricky because professional services are stringently regulated. Medicine, for instance, and there is a primary regulator that looks to make sure that they set the standards and that doctors, for instance, in medicine, live up to the ethical standards. However, the role of a consumer protection authority is not to set those standards. We don't have a competence to set professional standards. But when there's dissatisfaction and a consumer is injured, we would inquire to make sure that the applicable standards were complied with. And so in these two cases, there's what is the standard of care, which is a matter of law, both statute and case law. And then there are professional standards for the caregivers. And so what we would be looking at in both of these cases is to see whether these facilities or the care and the caregivers are complied with the applicable standard of care. If they didn't, and that's the reason why injury has occurred, there must be retribution for that. Whether there was misconduct by the individual professionals involved is something for the Medical and Dental Council. And this isn't the first time we've done this. We're currently prosecuting a medical professional for failure to truly cooperate and comply with an investigative process. And I'm prosecuting the case myself. The reason why for me, in things like medicine, to a large extent, is serious is because the questions that these professionals are called to answer many times could be defining for life or serious injury, quite unlike many of the other professions. And so because of that, there is a requirement that every piece where any regulator has a role, we focus on it. And there's no question about the fact that the healthcare delivery system in the country is much less than ideal. Now, am I picking on healthcare? No. As a consumer protection regulator, I get to see what's going on across the different industries. And so I'm not necessarily picking on medicine, but medicine is quite unique in the sense that there's no choice. It's not a fast-moving consumer good or a service that you can decide. I mean, even your telephone, even power, you can decide if you want it or you don't. Medicine is not something you wake up in the morning and say, you know what, I just want to go see the doctor today and purchase some medication. It's need-based. And because of that, it must be very strongly regulated, not just from the professional angle, but from the user angle and the consumers. And in these two cases, we followed information that was coming in. We've gathered enough information to decide that we need to open investigations into the both. We've commenced the investigation, which usually starts by the issuance of a notice of commencement of investigation and summons to produce under law. And the relevant parties, the treating facilities, have received the notice of investigation to commence. I believe the families and other relevant people would receive theirs before the end of this week, I hope, tomorrow. And usually you have some time to provide all the information we've requested. And so the information comes in. We have a team that analyzes this pursuant to the FCCPA. And then, of course, we've got the Patient's Bill of Rights, which was something that was promoted by the FCCPC and adopted across the country in 2018. The outcome of our initial review typically would proceed to what you call an investigative hearing. And that investigative hearing would focus on the key issues of injury, responsiveness, sensitivity, and whether the relevant parties complied with the applicable standard of care. And then we'll make our findings. And sometimes findings would be recommendations to a facility, even to the government, to other regulators. And sometimes a finding might lead to criminal prosecution. And sometimes it's a finding of injury that requires some kind of a mutual understanding that as much as possible compensates the injured consumer, in this case, families.
Okay. Well, one of the cases we're talking about now is that of a family that's accusing Premier Specialist Medical Center of negligence, which leading to the untimely death of Peju Ugboma. And so those cases, they got to the hospital. She had, of course, a medical situation, but just reading through the narrative, upon getting there, they demanded 1.5 million, he deposited $1 million, and then, but ultimately, eventually, you're investigating negligence here, but some of these cases are what many Nigerians can relate with. There's another case of Lara who equally to hospital in Arepo. So she got there. In fact, just reading through the story was, you would have thought, look, do these things, is this how medical professionals actually act? Because I mean, I just couldn't even go on reading some of those stories. The way it just went through. The nurses who were supposed to be a professional, the way they acted and conducted themselves there, they couldn't even give her oxygen. They thought, well, the referrals, all of those processes, and you thought, it clearly just shows you that there's a lot here. This is a huge job of work that the FCPC has got to grapple with, because time and again, for years, many people have talked about the Medical and Dental Council. I mean, before the show ends, I'm sure there'll be lots of litany of comments about how individuals have suffered or the experiences with medical professionals. But what exactly is the FCPC going to be looking at for here? Because yes, you said there's a role for the MDCN. So how do we ensure there isn't double jeopardy? So
what the MDCN does, like the NBA, if you were a lawyer, is to regulate professionals. And so, for instance, if someone carried out an operation and is not even an authorized, licensed medical doctor, MDCN has nothing to do with that person. And so that would be another regulatory mechanism, maybe a lawsuit or certainly the FCCPC to engage in that, because it's not on their roll. It's not subject to the regulatory jurisdiction of the professional licensing authority. Now, with respect to those who are licensed, what the disciplinary authority of any profession would do is to hold those professionals accountable to certain ethical standards or codes. It is, in some sense, there's some congruence because it is to also protect the people they serve, in some sense. However, the primary purpose of disciplinary frameworks in the professions is to ensure that professions are carried on in a certain manner and within the parameters of certain codes. And that's what the MDCN does. It redounds to the benefit of patients in the sense that you're making sure doctors live up to a certain standard without question. Now, with respect to potential injury, injury can occur even without misconduct. And so take medicine, for instance. We all desire a certain outcome when someone is unwell. But we don't always get those outcomes. Sometimes people have to live with certain medical conditions for the rest of their lives. Sometimes it even ends in fatalities. Does that necessarily mean that a medical professional has been less than professional? No, it doesn't. And so it's a different regulator who would look at that and say, in spite of your professionalism, your conduct has resulted in injury. Are there things you could have done differently to prevent that injury? If the answer is yes, you must be held accountable to that, because there's a wrong, there's an injury somewhere. There's got to be a remedy for the person who's been injured. And this is how we improve quality of care, whether it's medical or otherwise.
There's something that I'll still come to the question you raised about in the event in which the professional is not a member of a professional association, or like the MDCN. I'll still come back to that. But there's something you listed before we went on break, some of the qualities that are supposed to be expected from a caregiver or a service provider. And I was looking out for one of them, the timeliness. It wasn't included in what you listed. How significant is that, especially in the cases that we're looking at here now?
Well, I mean, in medical emergencies, I understand, I'm not a doctor, but I've been in these investigations a little, and I've tried cases that have to do with medicine. Time is one of the most important factors, and you're racing against time. And so, obviously, from what I have seen so far, these cases didn't start as medical emergencies, but they progressed into an emergency. And so, how timely, first, how prepared the facility was to even address what easily is a foreseeable emergency arising from a medical procedure is a question of the standard and quality of care. And that your preparedness, how well you were able to quickly respond, is also a question of the standard and the quality of care. And all of those things will be addressed in the investigative process. I've read a report that seemed to show a timeline. And you'd see that, obviously, whoever wrote that report understands what the stakes are and where the issues could be. One of the key issues on the Patient's Bill of Rights is, even in emergency care, timely and at least sufficient initial intervention to stabilize. I remember in the investigation we had last year, one of the key issues was how quickly did you respond to this victim? And secondly, what was the scope of the response? I mean, there's what you call the ABCDE of trauma, which requires primarily resuscitation and stabilization. And so it's not every time people come in with a medical emergency that an emergency occurs. Sometimes you go in with a regular issue, but it progresses at some point to an emergency. And a facility and the professionals are trained or expected to be equipped and trained for responding to such emergencies. However, an allegation of a lapse of time in itself will not necessarily result in a clear violation in some sense, because at the end of the day, it's only other professionals in that space, and not just any doctor. It's a trauma doctor or an emergency doctor or a surgeon or someone who has who's trained in a specialty similar to what this procedure was, who would be able to speak most authoritatively to what went wrong and whether the time was a big factor or not. But generally, I recognize that time is a big factor.
I asked that question against the background of something you said earlier, that the MDCN, for instance, in the cases under review here, regulates the practitioners. Who then regulates the practice?
Well, if you regulate the practitioner, in some sense, you are ultimately regulating the practice.
In some sense, which is the issue here, yes, now, because the factor on ground is that the person who needed the care went to a caregiver, assuming that they have all the standards I would need to get out of this alive and better. Yes. But that's not what exactly.
So there's a health act that defines what hospitals should be, what you would need to be able to take care of certain cases and what is expected of you. And so that, in some sense, is law. It also regulates the practice. Lagos State, and then there's some level of the state government regulation. So Lagos State has a healthcare facilities regulator that looks at the facility. Do you have what you're supposed to have? Is the medical director sufficiently qualified? And then we do not go around regulating practices or licensing or registering medical practices. Well, it doesn't matter. When a consumer says there's been a problem, we will get it, and all the issues that all these other people regulate will be factors we look at. For instance, if in any of these hospitals they're not even registered, that's a problem per se. Or if it turns out that a doctor is properly licensed, but he's not sufficiently trained for a procedure he was engaging in, while that's an MDCN issue for us, that's also a problem per se. Our own case, our role, so a standard setter, whether SON, NAVDAC, NDCN, and all of that, their role is to set certain standards. Many times their work ends when they set those standards and you've complied with the standards. But for us as a consumer protector, our work starts where their work ends. Because if, for instance, you've complied with the standards they've set, in all honesty, you probably are not liable under their framework. But our own role, we work our way back. There's been injury. What level of care did you take to prevent injury? And so that's where our own work is. So all these other guys who set standards, maintain, monitor the standards, they're so important. And so if you don't even comply with those standards, when you arrive with us, you are a dead on arrival. Because you didn't even comply with applicable standards.
Okay. If I can, tail on a question Chamberlain asked earlier. In these cases, in these two cases, there have been fatalities, and families' livelihoods have been affected definitely. There have been preliminary investigations and perhaps some preliminary findings. Is there any commonality in the two cases?
No. And the thing is that they're not joint. We're looking at each case separately. But if you're asking that, are there features, just looking at the initial information that is available, are there features that we've seen before in both cases and even in previous cases? The answer is yes. The answer is a general weak approach to healthcare, even by healthcare professionals. A general lack of urgency in our approach to addressing what sometimes could be very serious, as it has been in this case.
Even though, as you said, they are certified, they are registered, they are qualified, they are trained, yet this weakness is still there.
Yes. But I don't want to limit that to the medical profession. I'd say to you that, as a lawyer, as a litigator, I've been in court prosecuting cases and really concerned about how defense is carrying on, because I'm saying the stakes here are potential imprisonment for the defendant. And by the same token, as a consumer protection regulator, I've seen what I consider just a lack of urgency and sense of responsiveness in how we address issues, whether it's my airtime was taken, whether it's a failed transaction and I haven't gotten my refund. And so we've got a very long road to travel to bring our society to that point where we completely prioritize the subject or the object of the services we provide or the things we manufacture.
Because in many cases, it comes across as though the service providers make it look as if they're doing the consumer a favor. Because the consumer, whereas the consumer is actually, you have certain rights. You're going there to procure something, spend your money. Absolutely. But there still is this passenger bill of rights. When we took up the NCA, they said that airlines are supposed to have that displayed. Now there's patient's bill of rights. So, many will hear about it for the first time. They haven't seen it in any hospital, in any of those cases. They don't even know what they're supposed to ask, what rights do they have, and in many cases, people just throw their hands up in the air and leave it to God, per se. What is supposed to happen in that kind of case?
Interestingly, I in part wrote the passenger bill of rights before I got it. So it just seems like I go and create a bill of rights wherever we go. And in fairness, when the patient's bill of rights was adopted, a lot of the teaching hospital chief medical directors were there in Abuja. And I've been invited to some hospitals to formally adopt it and they display it. In fact, I was visiting someone in a hospital in Abuja recently, and just going into the elevator, I saw the patient's bill of rights displayed by the elevator. I think we still need to do some more work, and we've put it out there. It's available. Many people know about it. We've done seminars and all that about it. But the reality of it is that there's no regulator that can put out the information as much as the people who are accountable to the framework. Just like an airline is supposed to display the passenger, that's the best place to find out what your rights are as a passenger. And a hospital is the best place to understand or recognize.
The way, sorry to jump in, the way policemen will read your Miranda rights before
that is correct.
They pick you up.
That is correct. Because, I mean, where else do you go to find your rights as a passenger, especially if they haven't been violated? You're not going to go and start searching what are the rights of a passenger because I want to get on a plane. No. But you're engaging the airline to get on a plane. That's the best place. You're going to a doctor because you need care. That's also the best place to be advised of your rights. And we emphasize this. We're working with the regulators in the different states to see if they can adopt mandatory display of the patient's bill of rights as part of the registration and licensing procedure for hospitals and clinics within the state. Bottom line, ultimately, what is missing and most important is a consequence management system. If there are consequences for conduct, whether it is misconduct or just injury in spite of proper conduct, it will modify behavior.
Because I think that how far away are we? Because I mean, there's several complaints, and look, with due respect to the Medical and Dental Council, the every feedback we get is they need to be up and doing, you know, in terms of what needs to be done about all of those things. But when patients, what do we need to do as patients or as consumers in this case to ensure we play a role in holding those service providers accountable, either reaching out to FCCPC or professional regulatory bodies?
Demand and insist. Demand. There is the most powerful or potent component of a consumer rights enforcement framework is the consumer themselves. Demand your rights, demand information, request to be treated in the way you believe you should be treated. When you don't get it, insist on it. And when that fails, reach out to the regulator.
But are you getting a lot of feedback now? Because I know that there's a previous case you were handling. Some of those persons have been, I think the MDC has suspended some of them. What's going on with some of the cases as well? And
so I think the case you're referring to is a body modification medical practice. And so we're prosecuting that case. We're going through the judicial process. But the good thing about the role we took and the course we pursued is that it catalyzed others to act. It catalyzed the MDC and they suspended that doctor. And so people are no longer victims of that injury anymore while the case is going on. I intend to see this prosecution to the end.
Okay. Well, there's something on our timeline, Sunrise Daily now, on Twitter. It's by a Deep called The Deep. It says he made a complaint in 2013 and got feedback from the FCCPC complaints management system that work is ongoing, but just asking, that's the message right there. How much longer does he have to, how long more do I typically need to wait? This is from April 13th.
April 13th of this year?
Yes.
Okay. Well, so there's really no, I wish I could tell you that there's a timeline for resolving complaints. In April 13th, quite frankly, is not even that long yet. The reason is each of these complaints have different components. Some complaints are resolved pronto, in days. And I'll tell you that some have been months and months. And the reason is we do not provide whatever it is you set out to get. We facilitate or compel the satisfaction of what the issue is. We don't have an so for instance, if somebody didn't like the can of carbonated soft drink they purchased, we don't have an inventory to give you one. We've got to make sure. And many times there are disputes. You file a complaint, we reach out to the company, they completely dispute your account of what has happened. And the fair process is to evaluate all of this. And I'd say to you that there are complaints that are really not meritorious. And so it's not every complaint. So we've got to go through it. And I would also add that we receive about, 700 to 1,000 of these per week.
Wow.
It used to be about 700 per annum before I took on the role. But right now we're at about 700 to 1,000 per week. And we haven't expanded the manpower to handle these.
That's a challenge, right? Because going through some of your stream also on Twitter, you personally responded to some of those messages and say that even though the work has increased, the manpower hasn't increased. But in cases of, forgive me, firsthand how sensitive, how personal, how emotional some of these cases get. For the responses to take a little longer, to the person who is complaining, it will sound like the FCCPC is insensitive to my emotions. Meanwhile, the FCCPC is more or less shortchanged on itself. How do we, balance that?
We're working as hard as we can we're using technology, and just like you rightly said, I'm chief executive, but I respond to complaints. I'm handling complaints myself. I'm on my own, I'm on the timeline, I'm on the institution's handle and my personal handle, addressing complaints from there. And that's just one of the access points. And we put everything we have, we're leveraging technology as much as we can. But the big problem here is not, if we recruited another 2,000 people today, which quite frankly takes a while in government, and we're going through that. But even if we recruited another 2,000 people today, I'll be back here in 4 weeks, and those 2,000 people will be overwhelmed. What needs to happen is that companies and service providers need to get better at being responsive to their customers. Right now, you have the slightest, just a dissatisfaction with your chewing gum. You come to the FCCPC because the manufacturer or the producer has not created the proper mechanism for that feedback. And so just imagine how much time and expense it would take us to get in contact with a chewing gum producer to say, Chamberlain has a problem with this chewing gum. Are you guys going to sort it out? And then because they know it's Chamberlain and he can mess them up on TV, they just call you up immediately and say, Chamberlain, we're very sorry, we'll deliver 3 packs. Hopefully that resolves it. And we have an open file. So the system is broken. And one of the things that I'm looking to enforce is that companies themselves have a conflict resolution system. When we did the survey, you'll be amazed to find out that, including multinationals, many do not have a standalone complaint resolution system.
This is crazy.
I looked at products, cornflakes, drinks, all that, and I was looking on the bodies. There was nothing on who to contact if you're displeased. And I buy the same products in the shop in Tesco in England or Walmart in the US. And it's right there, same company. There's a place you go to. In fact, one of the few companies that passed the test and had a contact information on the product in Nigeria had a UK telephone number.
Oh dear. Oh boy, that speaks volumes.
Companies have to get to a point where they do not discriminate by markets on how they provide service. And so maybe companies are in for business and all of that. So that's one of the roles we must play as regulators. But we don't want to shock the market and just start whacking people all over the place. So we're moving there, and it's gotten better, although the road ahead is still long.
Yeah, and we all have a role to play in all of those things. But we do thank you for coming on. Mr. Babatunde Irukera is the Chief Executive of Federal Competition and Consumer Protection Council Commission. Thank you for coming on, and all the best.
Thank you. Thank you.